The next case on the docket is Douglas versus State.
Good morning, Your Honors. I'm David Henson. I'm here on behalf of Mr. Douglas. I'd like to reserve maybe 3 minutes at the end.
Okay.
This is an interesting little case to me in the sense that after Mr. Douglas was found guilty at trial of committing a battery on his girlfriend who was pregnant, which then made it an aggravated battery, he hired new counsel and filed a new trial motion alleging that he had received an unfair trial because of ineffective assistance of counsel. That put this issue, and here in the brief we have focused exclusively on the aspect of ineffectiveness that arose from trial counsel's decision to not ask for any affirmative defense instructions, specifically self-defense, defense of others, and necessity. This issue, of course, was put right in the lap of the trial judge by virtue of the new trial motion. The court held a hearing. The court determined really two things. One was that there was no trial evidence that would have justified the giving of any of these instructions. And secondly, that the alleged victim was far more credible than Mr. Douglas, and those were the stated reasons for why the new trial motion was denied. Ordinarily the denial of a new trial motion is a discretionary decision. I would tell the court that the court's discretion in this particular instance would have been narrowed significantly by the question of was there indeed evidence at the trial level through Mr. Douglas's testimony that would have justified the giving of these instructions. That's a low threshold. As the court knows, the standard is if there is any evidence that would support the giving of an affirmative defense instruction, the instruction should be given. And of course the reason for this is the simple one, and that is if that isn't the standard, then the defendant's defense never makes it to the jury. He has this jury trial that he has a right to, but someone in Mr. Douglas's posture...
What testimony supported giving the necessity defense instruction?
It was his testimony that when she has these diabetic episodes, she can become very erratic, that she will get into the car and drive and things like that. And here you have trial testimony both from him and her that she came in from work, she decided that she was going to...
And he testified that he physically restrained her in order to protect her from hurting herself during the diabetic episode, to protect the baby, to protect himself, and to keep her from driving so that she wouldn't endanger others.
Yes, exactly, Your Honor. That's the gist of the necessity testimony that would have supported a necessity.
So was the trial judge's decision based on the fact that he just didn't believe that testimony?
I think that it has a great deal to do with that, because I don't really understand why the court, and it was so obvious that there was evidence in the record that would have justified these instructions, including the fact that she bit him and then he responded to being bit in the course of trying to guide her to a place of safety. That I just can't help but think that what happened here was that the lower court got turned around, and let her own assessment of credibility influence, the issue of should this instruction have been requested, and had it been requested, would it have been the correct legal thing for the court to have given these instructions.
Trial counsel testified at the hearing, correct?
Yes, he did, and he testified that it was strategy.
Not that he forgot or didn't think about it, he made a conscious decision not to ask for it, right?
That is absolutely correct.
Okay.
Which, let me just,
And basically, his testimony was that he was hoping for a jury pardon. He was hoping that the jury would believe his client, right? That his client was trying to help her and keep her from hurting himself.
Exactly.
Her and keep her from hurting him.
Exactly.
And would do a jury pardon. But then that he didn't believe the client, so he didn't ask for the instructions. That was basically
reading between the lines, if we're going to be wondering why, how in the world do you get to this point where you've got your client on the stand, your client gives testimony consistent with defense of others and self-defense and necessity, and it's the same story that the client has been telling the lawyer from day one. Consistency. I think, reading between the lines, yes, I think you have obviously a breakdown in a relationship. You certainly have a breakdown in the adversarial process. For the attorney not to request legal defense instructions that would protect his client from conviction if the jury agreed with it.
Well, from the lawyer's testimony, the trial court concluded that the defendant was the aggressor, and the trial court specifically concluded that it was proper trial strategy not to request the instruction. Isn't that basically what happened? The trial court
Yes.
made those conclusions, right?
Yes, and my assessment of this record is that the state would have been fine to argue. It would have been the prosecutor's job to argue, perhaps, the debatable matter of whether this initial contact on his part was more than de minimis and would have met some sort of first aggressor type exception. But for the defense lawyer to come up with that,
The trial court listened to the defense attorney testify,
Yes,
and apparently
yes,
found the defense attorney
yes.
credible and believed what the defense attorney testified to, which was the defendant was the aggressor, and, it's not that he just didn't know about the defense, he considered that it would not have been good trial strategy to ask for it, and the trial court specifically found it was proper trial strategy not to ask for it.
I think there can be circumstances. What? Go ahead.
So the lawyer testified and the trial court believed him, but you're just saying that what the lawyer said just wasn't the basis for a finding that there was no ineffective assistance here?
That's correct. There can be a level of de minimis contact. That's why I had cited.
But my understanding of that testimony was that the lawyer concluded that his client was the aggressor simply because he touched her before she touched him. Is that correct?
Yes.
And his explanation was that he touched her because she was on the stairs and he thought she was going to fall and hurt herself, and that's when he grabbed her to lower her down to the ground so she didn't fall. So that was the first touch that he testified to.
That is correct.
And because he testified that he touched her first, the trial lawyer said that, well, I couldn't have asked for self-defense because he touched her first. That was his reasoning?
It was. I don't.
Self-defense, I guess, would have come in later when he testified that she bit him and he then restrained her to prohibit her from further attacking.
Yes, and the same trial lawyer somehow didn't remember, that his testimony had been that she had bit him because, either the trial lawyer or the judge went ahead and made the comment that there had been absolutely no conduct on her part that could have been considered aggressive.
And he testified she threw something at him. I think she testified to that,
She
too.
testified to that.
He testified she bit him or
Yes.
attempted to, and I thought he testified that she tried to strike him as well. But yeah.
Yes, it was his testimony that she bit him. He put his hands on her face and pushed her nose, and in response to that, she became hysterical and started flailing at him. So that was the gist of that.
Did the attorney testify that all that evidence was presented to him and he still made the decision not to ask for the defense, or did the trial counsel testify, well, he never explained all that to me?
No, there was no indication in the trial lawyer maybe said a lot of things that, reading between the lines, you realize he didn't like this client very much. But one thing he never said was, I never heard that before.
Well, and he heard it from the witness stand, and then chose not to ask for the instructions, right?
Yes, but no, I do believe this is a situation where it was not only on the witness stand, but this has been this guy's story from day one, and this is what the lawyer would have known leading up to trial even. So, from the perspective of this court, when is it appropriate to deal with ineffective assistance on direct appeal? When it's obvious on the record. And I think that the defendant's testimony at trial, as well as the additional testimony that he gave at the new trial motion hearing, puts this court in the appropriate position to reverse the order denying his new trial motion. So I'd like to sit and if the court doesn't have any other questions.
You want to reserve the rest of your time?
Sure.
3 minutes
Sure.
and 52 seconds, all right.
So the defendant testifies that my first contact with her happened because she was unsteadily coming up or down the stairs and was about to fall, and I grabbed her to ease her to the ground so she didn't hurt herself. Is that about right?
No, I sort of disagree with that. He said he got her a glass of juice, put it on the armrest, and encouraged her to come over and drink it. She was paralyzed at the stairwell, and he went over to help escort her to the couch. The stairwell and storage boxes were not a good environment for her to fall down. When he tried to move her, she resisted in a not balanced fashion. And that's when he couldn't get her to the couch. The only thing he could do at that point, after he'd already run over and confronted her, was walk her down to the ground.
Trying to aid her to the couch so she didn't fall is the way I read that, right?
After he had already gone over there and was telling her to drink juice, she was just standing by the stairway. She wasn't doing anything.
And you're telling me that in a battery prosecution where he's being charged with touching her against her will, that wouldn't get you an instruction on defense of others? I was trying to make sure she didn't fall. She was in a diabetic state. She was unstable, and I helped her to the couch. That wouldn't get you
There was no evidence at that point that she was in a diabetic state and was ready to fall. She was paralyzed. She was paralyzed at the stairwell.
Part wasn't that because either the trial judge didn't allow that evidence or the attorney didn't, I don't remember, but he wanted to put on evidence about the way she reacted in diabetic states in the past, and that wasn't done, correct?
That might be.
Yeah.
I'm not 100% on that, but anyway, the issue here is not whether a self-defense instruction would have been given.
So you concede he could have gotten one based on the testimony?
No, I don't think he could have. I think he was the aggressor in this. He walks her down to the ground, and then he hits her across the face a couple times with the back of his fist.
That's her testimony, but don't you look at whether there's any
Well, his
testimony to
testimony, too.
support the instruction?
That was his testimony, too. His only thing was he had hold of her by the upper arms and walked her down to the ground. When he released her arm and put it behind her head, she bit his arm. Counsel said he looked at pictures. There was no evidence of any bite marks. Again, we don't look at whether he would have gotten the instruction. We look at whether counsel's decision not to ask for one was reasonable.
Bites him, and then he restrains her, and she tries to swing at him. That doesn't get you a self-defense instruction?
No, because he's the one who brought her down to the ground and was holding her to the ground. She was trying to get away from him.
Where's that testimony she was trying to get away from him?
That was her testimony. I mean, and his testimony supports it. She was trying to get her arms away from him. She was trying to get up. And then he took his hand and pushed it up against her nose to elicit a pain response so that she couldn't move.
Okay, just assume for purposes of the question that you could have gotten a self-defense and necessity instruction based on his testimony, whether it's credible or not credible, doesn't matter. I mean, if there's some evidence, you get the instruction on the defense. So assume that you could have gotten it. What reasonable counsel would put on testimony of self-defense and necessity, would argue that to the jury is the basis for not finding your client not guilty, and then not request the instruction and explain that, well, I didn't believe the testimony? What rational, reasonable, competent lawyer does that?
A lawyer who doesn't want to have to listen to the prosecutor stand up there and go, really? This 6-foot-tall guy had to use self-defense against this tiny woman?
Didn't he argue my client was only, you've heard my client, he was only acting in self-defense, it was necessary, she was in he argued the facts that he put on with his client's testimony, right?
He was arguing that he was trying to help her,
Right.
not that he had to defend himself against her actions. And that's what he was hoping for, that the jury would find he did not have the unlawful intent that was necessary for the state to prove the battery. He was not arguing that he was protecting himself from this woman. No, he did not argue that.
Okay.
He was arguing either for a pardon. I mean, they'd lived together for like 7 years. She was pregnant. I mean, this wasn't just kind of a spur of the moment. They just met each other, and he went off on her. So he was faced with a lot of circumstances here. And he said, his client started it, even if he hadn't. There were no bite marks in the pictures. She got the worst of it. I mean, they had pictures of it. She was a lot smaller than him, and one of the biggest issues that he said he had was that the EMT showed up very shortly thereafter and saw no evidence whatsoever of any diabetic distress. And they both said they have a lot of experience with that. The call was there. That was the call they were responding to, was diabetic distress. It wasn't a domestic
I understand
incident.
the credibility issues with his testimony, but I just don't understand putting your client on the stand to elicit testimony that would be your only defense, basically arguing your only defense, but then not asking for the jury instruction. Even if you don't argue it, why not argue it? If it's the only available defense that you have and you put on the testimony, why don't you ask for the defense? It just doesn't make any sense as a matter of strategy.
Because I said, his defense was he had no lawful intent.
Okay.
That is an element, that's a requirement. And again, he's got to maintain credibility with the jury, too. And looking at all the circumstances, I think that his strategy was reasonable. The trial court...
That strategy was hurt when the prosecutor could stand up in argument and say, you're not going to hear any instructions from the judge about self-defense or any kind of justification like that. You're not going to hear about necessity. If he touched her against his will, that's the crime. I mean, you don't think that hurt his argument?
I think necessity definitely doesn't apply in this case. I mean, you have to, there has to be imminent threat of death or serious bodily injury. The defendant didn't intentionally or recklessly put himself in the position. There were no other means to prevent this. The harm sought to be avoided was more egregious than the criminal conduct and ceased as soon as the necessity ended. Apparently the necessity ended, and he's on top of her going, if you want to get up, you have to apologize to me. And she said, okay, I'm sorry. And he said, that's not good enough. You need to apologize again. So, counsel was facing some uphill battles with this case. So I don't think necessity clearly didn't apply in this case. Self-defense...
Isn't that basically why the trial court kind of thought this was an appropriate trial strategy, not to use that defense because of all those factors you kind of outlined? I mean, here's this tiny little pregnant woman and here's this big guy that has to defend himself from the throes of a woman that's in apparently, according to the defendant, in a diabetic distress, and it just wouldn't have been credible. And I think maybe the trial court, it seems to me, thought that taking all that into consideration, it just wouldn't have been a good trial strategy, and that's why he found that it was, to keep it out, right?
Exactly. Exactly, and that's all that's required under Strickland. If there are no further questions, I would ask this court to affirm the order of the trial court. Thank you.
Does the court have any questions of me?
I mean, isn't that basically what this is all about? I mean, you've got a trial judge that listens to the defense attorney testify. The defense attorney said, this was not my trial strategy to ask for this sort of a defense based on all the factors that Ms. Nealon just outlined. I mean, does it make sense that the defense attorney is going to seek credibility from a jury and try and argue that too? I mean, this tiny little woman that's pregnant, and here's this big guy, and he's having to defend himself against her, and she's supposed to be in diabetic distress, and he's seeking self-defense? So what? The solution of the trial attorney is just to leave his client out to dry? I mean, you don't want to lose credibility with the jury by putting on a defense that can be considered as ridiculous either.
Your Honor, it's not ridiculous.
Why isn't it?
It is the jury's decision to determine whether there was self-defense here. It is.
You have trial strategy, and you want a favorable verdict from the jury. You don't want to put on a theory of defense that's the trial attorney is going to think is going to lose him credibility with the jury either.
I don't think
You don't think that this defense would have lost the attorney and the defendant some credibility with the jury by making that argument?
What? It's not a popularity contest. I mean, he has no defense to the charge based on what his lawyers did.
Well, his
You know, you
theory
take the
was-
good
his
facts,
theory
you take
was
the-
that he didn't intend to do anything to harm her, and therefore he's not guilty, right? Wasn't that
Yes.
basically it?
Yes.
And then you're going to put on a defense that here's this big guy with the tiny little pregnant woman that's supposed to be in the throes of a diabetic, and he's claiming self-defense against her, and he's the one that and the pictures showed that the injuries to her face and everything else, and he's the one claiming self-defense? I mean, I'm just trying to look at it from...
Eliminating the client's sole legal defenses is not the answer. I realize, I realize you have unfavorable facts. I realize you have to deal with things. But the
lawyer has to-
lawyer has to do all kinds of things.
Then we want to say, well, he was ineffective because...
The competent lawyer does not jettison the client's only defenses, in the name of trying to win at trial. I mean, that's just, Your Honor, that's just extremely unusual.
The trial judge apparently thought it was good trial strategy to...
Well, that's why we're on appeal, and we're asking this court to reverse the trial judge. And thank you. It's good to see you all. Thank you.
Okay, thank you both. We'll argue on both sides. Thank you.